In India, marital rape in general is not punishable. However, a special category of marital rape is introduced under Section 376B and has been made punishable. If a husband wants to have sexual intercourse with his own wife and the wife is living separately, then he must obtain her consent, because if he commits sexual intercourse with his own wife without her consent in this situation, then it is punishable under Section 376B with a minimum punishment of imprisonment of 2 years and the maximum punishment of 7 years. In India, now it is an offense to have sexual intercourse with one's own wife without her consent if the wife is living separately, whether under a decree of separation or otherwise. So even when the wife is living separately at her own volition, on her own accord, the husband cannot have sexual intercourse with her without her consent. If she is living with the husband, then of course, under the present law, for having sexual intercourse with his wife, the husband need not obtain her consent. The scope of the expression sexual intercourse has been enlarged in line with the definition of rape under Section 375. The expression sexual intercourse now includes all of those acts which are specified in clauses A to D of Section 375. In all these preceding sections, we learnt about the provisions which prescribe punishment for a person who commits the offense of rape. In this section 376C, we have a provision which punishes a person who commits a sexual intercourse which does not amount to rape. This section applies only to certain special categories of persons. This section applies to a person who is in a position of authority or in a fiduciary relationship with the woman with whom he has sexual intercourse. It applies to a public servant in whose custody that woman is. It applies to the superintendent or manager of a jail, remand home or other place of custody, or a women's or children's institution. It also applies to a person who is on the management or staff of a hospital. If any such person abuses his position or fiduciary relationship to induce or seduce any woman who is in his custody or under his charge or present in the premises and has sexual intercourse with her, such sexual intercourse not amounting to rape, even then he is liable to be punished with rigorous imprisonment of minimum of 5 years and a maximum of 10 years. From Section 375, we know that a sexual intercourse will not amount to rape if it does not fall within any of the 7 circumstances which are described in the second part of Section 375. It needs to be noted here once again that sexual intercourse now has an extended meaning. It will include any of the acts which are specified in clauses A to D of Section 375. So, Section 376C will be applicable if the person mentioned there commits any of the acts specified in clauses A to D of Section 375, but not within any of the circumstances which are specified in the second part of Section 375. The word superintendent in this section will also include a person who is holding any other office there in the jail or remand home or other place of custody, if the office is such that by virtue of that office he can exercise authority or control over the inmates of the jail, remand home or institution. Section 376D and the following two sections 376DA and DB contain provisions relating to gang rape. This first section contains provisions relating to gang rape of any woman, whereas the next two sections contain provisions relating to gang rape of special categories of women. The expression gang rape has not been defined in any of these sections, but its meaning can be inferred from the text. The act of gang rape, as it appears in section 376D, involves rape of a woman by one or more persons. In the very beginning, I would like to make it clear that it is not necessary that rape should be committed by more than one person. It is sufficient even if rape is done only by one person, provided the second condition is satisfied. In an incident of gang rape, there must be more than one person around. All these persons should have acted in furtherance of a common intention, or at least they should have constituted a group. As far as intention is concerned, there is no specific requirement that the members of the group should have any specific intention. Section 376D is a deeming provision, and it provides that each of the persons who constituted the group or who acted in furtherance of a common intention shall be deemed to have committed the offense of rape, even if the rape was actually committed by any one of them. The mere fact that the person was a member of the group is sufficient to hold him guilty, even if this person committed no wrong, he committed no act during the incident, and also he had no guilty intention. Every person who is deemed to have committed the offense of rape under this section is liable to be punished with rigorous imprisonment of not less than 20 years, which may extend to imprisonment till the end of that person's natural life, along with fine. And the amount of fine shall be just and reasonable to meet medical expenses and rehabilitation of the victim, and the entire fine which is imposable under this section shall be paid to the victim. The effect of this deeming provision under section 376D is that a person who has not actually committed rape is deemed to have committed rape, even if only one of the group had committed rape, or even if rape was committed by one of them in furtherance of the common intention. What is meant by common intention? The expression common intention denotes action in concert and necessarily postulates a pre-arranged plan, a prior meeting of minds, an element of participation in action. The acts may be different and vary in character, but must be actuated by the same common intention.